Welcome once again to Lehto's Law. Here's Steve Lehto.
Had a whole bunch of people send me this story yesterday, and it made news all across the nation. The Supreme Court handed down an interesting ruling that will make it easier to sue the police for malicious prosecution. I'm going to go with the story from NPR. Nina Totenberg wrote it, but it's widely covered. In fact, you can also go and look at the opinion yourself if you want to. But the U.S. Supreme Court Monday made it easier to sue police and prosecutors for malicious prosecution. But the decision still leaves in place other barriers. So this is not just a slam dunk going forward, but it lowered the standard as to what you have to go through before you can sue them. At the center of the ruling is a case involving a baby with diaper rash. We kid you not. Larry Thompson was living with his then fiancée, who's now his wife, and their newborn baby when his sister-in-law, who, according to all the stories, was apparently suffering from mental illness, called 911 claiming that Thompson was abusing the baby. EMT officers arrived and they were let into the apartment by the sister-in-law. But Thompson, who did not know that 911 had even been called, told them they must have been at the wrong address. There's nothing happening here. Don't know why you're called. You guys can leave. They, in fact, did leave, and then returned to the apartment with 4 NYPD officers. This time, Thompson answered the door and said, "Unless you guys got a search warrant, I'm not letting you in." The police then threw Thompson on the floor and handcuffed him while the EMTs examined the baby. All they could find in the baby was diaper rash. But the baby was taken to the hospital and they confirmed the diagnosis as diaper rash. Thompson, however, was thrown into jail, spent 2 days in jail, and was charged with resisting arrest and obstructing governmental administration. Obstruction of governmental administration. Prosecutors eventually offered him a plea deal, which would leave him with a clean record if he followed through with everything. But he refused on principle. No, I'm not going to plead to anything. I didn't do anything. He refused, and prosecutors dropped all charges. What was your explanation? They didn't give one. They simply dropped all charges without explanation. Thompson filed a lawsuit alleging malicious prosecution. But under the federal appeals court precedent in New York, Thompson had to prove that his innocence had been affirmed. He had to, in essence, show that the courts had found him innocent, which, by the way, courts don't actually do that. It's a problem, isn't it? So the dropping of the charges without explanation was not enough. So that court threw the case out. So they took the case to the U.S. Supreme Court, who spun this around. And on Monday, they sided with Thompson in declaring that he did not have to show an affirmative indication of innocence. The vote was 6-3. Justice Kavanaugh wrote for the majority in here and said that a plaintiff need only show that his prosecution ended without a conviction, and that Thompson did that here, therefore he should proceed with his lawsuit. And some people are going to say, Steve, this is crazy to lower the standard this far. Do you understand that when you get put on trial and you're found not guilty, that's not an affirmation of your innocence, and that wouldn't do it in the old days. How often do courts actually say this guy is innocent as opposed to not guilty? And I've mentioned before, I wrote the book with Timothy Masters about how he spent 10 years in prison for murder he did not commit. And they released him, and he wound up filing lawsuits against the various parties, and they settled those. And it became very, very clear that not only did he not do it, but that they had screwed up the investigation so badly and focused on him for all the wrong reasons that they really messed up. And that's one of the reasons they settled the lawsuits the way they did. But the district attorney's office held a press conference in later years, long after Tim had gotten out of prison, held a press conference and announced Timothy Masters is innocent. He did not do it, shouldn't have been arrested, shouldn't have been charged, shouldn't have been put on trial. Okay? And the DA announced that at a press conference. And you have to understand what an unusual thing that is. And so in the old days, if you actually had to prove not only that they didn't prosecute you and didn't get a conviction, but that somehow they also affirmed your innocence, that was an impossibly high standard. So that's what Kavanaugh wrote about, and he points out that simply ending without a conviction is enough. And remember that you are innocent until proven guilty. Therefore, you're not proven guilty, you must be innocent. So that, in effect, becomes the affirmation necessary, according to this opinion. A Georgetown law professor who filed a brief on behalf of 70 former prosecutors wrote, "This is a welcome development that allows police and prosecutors to be held accountable when they do something wrong. Until this decision, in many jurisdictions, it didn't matter that someone had framed an innocent person, completely upending their lives." That is the man's attorney speaking. "If the charges were dismissed, there was no redress for the wronged person, unless a court affirmed his innocence," which, like I said, they never do. Meanwhile, Michael Bromwich, who has spent years as a prosecutor, a defense lawyer, and as an inspector general for the U.S. Justice Department, said, "I think it's a long overdue ruling. Prosecutors get away with way too much when they realize they may not have a case and want to protect law enforcement from liability. So if they think the case is really bad, they could just drop it in the old days and say, well, you didn't go to trial, you didn't affirm your innocence, you can't sue us, sorry." So Bromwich, like the other experts, does point out that this ruling, while making things easier, is not going to make it a cakewalk. This is not an open the floodgates decision, he warned. Indeed, the court's opinion specifically remanded Thompson's case back to the lower courts, where other defenses can still be raised by law enforcement officials. As Georgetown University law professor Paul Butler observes, these civil cases are tough to win, and when you do win them, the damages are often very small, so it can be very hard to find a lawyer. Now, he and McCord, who are both former prosecutors, note that there remain other tools that immunize police and prosecutors from being sued, and as Butler put it, it's not as if the Supreme Court's conservatives suddenly got woke. Liberals should take no heart from a methodology based on the understanding of tort law in 1871. And that's because in Justice Kavanaugh's opinion, that's the written opinion of the court, it was indicated the court must start its analysis based on torts available in 1871, because that was the year Congress passed the law authorizing lawsuits against state and local officers who deprive individuals of their rights under color of state law. But that is not necessarily the understanding of tort law today, because 1871 was a long time ago. I barely remember it. So dissenting from the ruling were Justices Alito, Thomas, and Gorsuch. Writing for those three, Alito said what the court has done is to recognize a novel hybrid claim of uncertain scope that has no basis in the Constitution and is almost certain to lead to confusion. Well, one thing you have to understand is that the court often has to talk about how we determine whether something has been done, not done, et cetera, et cetera. And the question is, if you are allowed to sue the police for something, if the statute doesn't explicitly say you can sue for this but not for this, well, then someone's got to figure out what that is. And the standard of requiring a former defendant to prove not only that he wasn't prosecuted or that he was found not guilty, but that his innocence had been affirmed is a crazy high standard, because it never happens that your innocence is affirmed by somebody. It almost never happens, almost never. And so, like I said, in Timothy Masters' case, that's why it made headlines, is because the district attorney's office held a press conference and said, this guy didn't do it. And they apologized. So when it makes news like that, it's unusual. And so that would be unusual, but the standard has now been lowered, which is good in my mind, because if you get wrongly arrested and spend a couple nights in jail over something stupid like this, and then they decide not to press charges against you, and because they don't press charges against you, you can't sue them for what they've done, that didn't make sense. And so I think the Supreme Court did the right thing here. So again, the story is by Nina Totenberg from NPR. Supreme Court makes it easier to sue the police for malicious prosecution. Sent to me by Rob, Neil, Joseph, Christopher, Michael, Kevin, James, and Daryl. Thank you very much. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Computers make very fast, very accurate mistakes.